The International Criminal Court is now in session.
Good morning. I hope you can all hear me. Welcome to the round of the last 16 of the Nuremberg Moot Court in the case of the prosecutor versus Mr. Gravus. I will start by introducing the bench. This hearing is presided over by Judge Doi, Judge Bülte, and myself, Judge Kasande, who I will be presiding over the hearing. We'll now take appearance of the parties, starting with the prosecution. Please indicate how you'll split your time and the order of appearance.
Good day, Madam President, Your Honors, esteemed colleagues. My name is Tamar Gobadishvili, and I will be acting on behalf of the prosecutor on this matter. I will take up 10 minutes of our total time, and my co-counsel, Ms. Mariam Gahide, will address the rest of our submissions in 15 minutes. We reserve 5 minutes for our rebuttal. Thank you.
Thank you. Defense?
Your Excellencies, I'm Ishan Arachi, and my co-counsel is Teshani Valigamage. We represent Mr. Gravus in today's proceedings. I'll be speaking for the first 10 minutes, and my co-counsel will be speaking for the remaining 15 minutes. We receive 5 minutes for rebuttal. Thank you.
Okay, thank you. Prosecution, you may proceed.
May it please the court, the OTP submits the following 3 claims. Firstly, the case is admissible before the court pursuant to Article 17. Secondly, the court has material jurisdiction over the case, and finally, there are reasonable grounds to believe that Mr. Gravus is criminally responsible for the crime of genocide under Article 28 of the Rome Statute. Before moving to the first submission, the OTP would like to clarify the burden of proof primarily lies with the party challenging the admissibility of the case before the court. Therefore, the defense must demonstrate the inadmissibility of the case at hand with evidence of sufficient degree of specificity and probative value. Also, the appeals chamber made these pronouncements in a Gaddafi case in the context of inadmissibility challenge lodged by a state. The ruling is still applicable to our case, since there is no reason why the standard of proof for an individual bringing an admissibility challenge should be different from that of a state. Your Honors, bearing in this mind, the OTP will now address the first submission and prove that the case is admissible before the court based on 2 grounds. First, the Republic of Vanuatu is neither willing nor able to genuinely carry out the investigations pursuant to Article 71A. And second, the case is a case of sufficient gravity to justify further action by the court pursuant to Article 71D. As an initial point, there is no evidence to support the defense claim that allegedly ongoing investigation covers the substantially same case on the Republic of Vanuatu has taken tangible, concrete and progressive investigative steps to ascertain whether Mr. Gravus is responsible for crimes committed in Castelia. Your Honors, as deliberated by this very court in its practice, investigative steps could be interpreted as interviewing witnesses or suspects, collecting documentary evidences, or carrying out forensic analysis. The Republic of Vanuatu has implemented none of ever mentioned. While the defense might argue that detainment or imprisonment of the accused is sufficient proof to suggest that initial investigative steps has been taken, in reality, the imprisonment and detainment can be easily explained by the fact that Mr. Gravus was forcibly removed from the power. Moreover, the accused has been detained 3 months prior to launching the investigation, once again proving that his detainment is not motivated with the intent to bring perpetrators to justice. And even if the court were to find the allegedly ongoing investigations to be covering the same person as substantially same conduct, the Republic of Hanatun is unwilling to carry out the investigations accordingly. The unwillingness criteria should be assessed in the light of the principles of due process. Also, the ICC is not a human rights court, but human rights standards may still be of relevance, of utility, in assessing whether the proceedings are carried out genuinely or not. The rule of complementarity, which is spelled out in Article 17 of the Rome Statute, the interpretative provisions in Article 21(3) and the theological approach confirms that if the court is not satisfied that the right of accused will be respected in a national investigation and in national criminal proceedings, the claim will be admissible. Your Honors, let me draw your attention to the surrounding circumstances Mr. Gravus' detainment. On 1st September 2021, the situation destabilized in the capital of Hanatun due to clashes between Mr. Gravus and his deputy, General Hitch. On 13 September 2021, a military coup led by General Hitch toppled the government, and he declared himself as a commander-in-chief of a central government. After that, Mr. Gravus was placed under house arrest and later held in prison in Hanatun 3 months before the investigation would start. Bearing in mind this political context, it is evident that Mr. Gravus' fair trial rights cannot be ensured by the military court. Furthermore, there is no evidence to suggest that court proceedings were conducting independently and impartially. And proceedings which are conducted independently and impartially imply that the court trials should be trustworthy for the objective persons. The prosecution is aware that the fact the court was founding after the military coup does not by default imply that lack of independence and impartiality. However, in a given case, facts indicated just the opposite. First and foremost, the military court was created following the pressure of national and international human rights organizations. Once again, it's highlighting unwillingness on the part of states concerned. Additionally, not a single person has been tried or convicted over the course of existence of a military court. Your Honors, understanding of the relevant context is crucial in this case. Following the overthrow of Mr. Gravus' government by General Hitch, impartial and objective proceedings would not be desirable for the new government, who were former subordinates of Mr. Gravus, considering their role in commission of a crime of genocide that has taken place in Kastyria. Thus, the military court fails to meet threshold of independence and impartiality. Moreover, the Republic of Hanatun is unable to carry out proceedings accordingly. Specifically, due to substantial collapse and unavailability of international judicial system, the Republic of Hanatun was pressured to create a military court outside of its established judicial system. However, there is no evidence to suggest that this new tribunal was able to obtain either necessary or testimony or otherwise carry out proceedings as stated in Article 17(3) of the statute. To conclude the first of our first submission, the national investigation is not covering the same case, and the Republic of Hanatun is neither willing nor able to genuinely carry out the investigations pursuant to Article 71A. May it please.
Counsel,
yes.
Counsel, if I may interrupt. You mentioned that the military court is not investigating the same conduct in the same case. Do you have evidence to that effect? And what requirements would you have to present to this court to demonstrate that they're investigating the same case and the same conduct? Does the military court have to investigate the crime of genocide, or would ordinary crimes within its jurisdiction suffice for this court?
Thank you for your question, Your Honor. Yes, I have mentioned that the court was not investigating the proceedings impartially and accordingly to. This military court was not investigating the same case. There is no information from the case that this court was investigating the same case about Mr. Grabus' responsibility. It is only mentioned that September 2015. There is no information in the case that it was the same case and the military court was investigating the same case, which is referred to the Mr. Grabus' responsibility. For example, now the crime of genocide. May I proceed? May it please the court? Please. The prosecution will now move to the gravity criteria. Before addressing the relevant test for gravity assessment, the OTP would like to provide the court with a relevant context explanation, highlighting the fact that UN Security Council, acting under Chapter 17 of the UN Charter, referred the situation to ICC. Given the Security Council's role and mandate, it becomes evident the crimes committed against Castilians pose a serious threat to international peace and security. Once again, proving a case at hand of sufficient gravity. However, the OTP will employ three tests.
Counsel, if I may, yes. The Security Council only refers situations. So is it the prosecution's position that every case under such a situation would be sufficiently grave to be heard before the court?
When the United Nations main aim is that international peace and security, and when the UN Security Council refers the situation to the ICC, it means that we know the Council's role and mandate, and it becomes evident that in our case, the crimes committed against Castilians pose a serious threat to international peace and security, and the international organizations' pressure to create the military court was the example of that this situation which was happening in the Republic of Hanatun was a threat to international peace and security.
But is that true for each individual case that arises from that situation? Or could there be cases in a situation which were insufficiently grave to be heard before the court?
Can you repeat the question, Judge?
Yes, this UN Security Council refers a situation as a whole.
Yes.
So is every case from that situation, for example, the case against Mr. Grabus, sufficiently grave to be heard before the court?
Yes, it has sufficient gravity. That is why it is, yes.
Thank you, Counsel.
However, I will continue. However, the OTP will employ three tests proving that case at hand of sufficient gravity. First, the senior leadership test. Second, quantitative assessment. And third, the qualitative assessment. Starting with the leadership test. The ICC has indicated the gravity threshold was intended to ensure the court pursued cases only against the most senior leaders in any given situation under investigation. The emphasis of senior leaders is further justified by the relevant practice of ad hoc tribunals. Let me remind you of the fact that Mr. Grabus was the president of Commander-in-Chief of the Armed Forces and Security Apparatuses of the Republic of Hanatun, thus considering that position and role played in atrocities committed in Castilla. Mr. Grabus is undoubtedly the most senior leader, justifying the investigation in his potential crimes by the court. Given the determination of whether the threshold of gravity is satisfied requires the objective quantitative and subjective qualitative assessment. The prosecutor will first address the quantitative dimension. The ICC does not a specific requirement for number of casualties constitute a grave crime. Within one night, in 15 July 2019, 200 Castilian men were murdered, 86 more were shot in head, and 150 female Castilians were arrested. In addition, while assessing the quantitative dimension of the gravity, both direct and indirect victims should be taken into consideration, as well as other damage caused by the crime. As a man, we are murdered in cold blood. The blockade of Castilians resulted in severe famine throughout Castilla. Social images which showed the dead bodies of women and the children on the streets on multiple occasions, SPG officers who were kicked pregnant women in the stomach, and the girls were taken by the SPG officers to the different stations where they were forced to cook and provide sexual services. Therefore, the overall number of direct and indirect victims, together with the damage caused by the crime, renders the case at hand of sufficient gravity. As for the qualitative criteria, numerous factors would serve as a useful guide, including the severity of harm occurred, the nature of unlawful conduct, which means that used to commit the crime, the social alarm caused, and circumstances of manner, time, and location. The prosecution submits that the manner of the commission of crimes should be assessed in the light of following factors. First, the extent of which the crimes were systematic or resulted from a planned or organized policy, the existence of elements of particular cruelty, including vulnerability of the victims and any motives involving discrimination held by the direct perpetrators of the crimes, the use of rape or other sexual gender-based violence. Honorable members of the court, Mr. Gravus declares an organized campaign aimed at destruction of not solely CNF members and their supporters, but specifically supporters of destruction Castilians ethnicity, demonstrating the presence of the plan from which the crimes originate. Regarding the scope of victimhood, only pregnant women were kicked in the stomach. Your Honors, there were circumstances, evidence of sufficient gravity, social alarm caused by the severe situation in Castilla. As ICC stated in Lubanga case, the social alarm component of the test is particularly relevant, while the OTP is aware of different factual circumstances of the case. Your Honors, conclude to prosecution's first submission. The case against Mr. Gravus is admissible pursuant to Article 70, and the court, as the Republic of Anatun, is not willing nor able to carry out national investigations accordingly. Mr. Madam, Your Honors, if there is no further questions, I would like to give the floor to my co-counsel.
Okay, thank you, counsel. Counsel, you have the floor.
Thank you. Madam President, Your Honors, good afternoon, may it please the court. My name is Maria Mikakidze, and I'm appearing on behalf of the prosecution. My co-counsel, Mrs. Tamar Gobachishvili, showed the court that there is a sensible and reasonable justification for belief that the crime falling with the jurisdiction of the court has been committed, and the court should have exercised its jurisdiction under Article 17 of the Rome Statute. Your Honors, during the next 10 minutes, I will prove that the first, crimes committed against Castilians was a crime of genocide, and second, Mr. Gravus, as a commander, is a criminally liable for the crime of the genocide. Starting with the first issue, the prosecution will state the following elements. The first, Castilians constitute a protected ethnic group. Second, crimes were committed against Castilians to destroy them in whole or in part. Third, crimes targeted Castilians based on their ethnicity as such. And finally, perpetrators have those specialists to destroy Castilians. Starting with the first point, prosecution states that Castilians are a group who are identified as a different ethnic group. They have different culture, and because of these differences, they were settled in a different place. They have permanent and stable living in the Castilian during 3 centuries, and they have a tight link to this territory. According to Akayesu case, paragraph 513, an ethnic group is generally defined as a group whose members share a common language or culture. Ethnic minority, the Otaki-speaking people, were the majority population in Castilla. They have their own territory, their own culture, language, religion, political and economical life. Your Honors, let me draw your attention to the both elements of definition of ethnic group. there is not the only subjective element that the historians consider themselves as the representatives of different ethnic groups, but an objective element that the others consider them as a representatives of different ethnic groups. The difference may try to argue that historians represent political group, which will be absolutely irrelevant in the case because there is not the political group by its definition. There were concrete elements appropriate with the definition of ethnic group, because despite the fact that according to AKSO, elements of ethnic group is alternative, we have cumulative elements in this case, which means that historians have their own language, also culture, and they represent different ethnic groups. The following issue, as it was already have mentioned, is that there were committed concrete crimes against historians to destroy them in part. There were facts of centrally organized and separate massacres against historians. 286 men died. Others were objects of enslavement. Women and their children damaged by the kicking, and children and women died by the sever famine. With the elements of genocide by killing, there were also the elements of genocide by deliberately inflicting conditions to life calculating to physical destruction. The trial chamber in paragraph 505 in AKSO case held that this expression should be constructed by the means that the perpetrators does not kill the members immediately, but seek their physical destruction. In the case, it was expressed by the kicking pregnant women, by the forced sexual services of girls, and sever family. ICTR trial chamber in AKSO case, paragraph 116, states that the conditions of life could include rape and starving of group of people. In addition, kicking of the pregnant woman was intended act to reduce the new generation of Castilians, and also Castilians were forced to leave their houses, and if in the case of the resistance, they were killed. There were the concrete above-mentioned crimes against Castilians, and all these crimes in unity have the required gravity. The fact that Castilians were targeted of committed crimes as such of their ethnicity is based on the campaign of Mr. Graus. The defense might speculate that not only Castilians were the members of the CNF, but the other groups also. However, in the case there is a direct fact that the security forces should take any or and all necessary measures to destroy Castilian supporters, which states that only Castilians were targeted group for the perpetrators. Your Honors, let me draw your attention to the fact that Mr. Graus was called cancer and lying rates to the Castilians, not to the FNC members or other group. Your Honor, with your permission, I will move on the third element, fourth element of special intent. And in order to show the existence of judicial intent against Castilians, the prosecution relies on the key components of Mr. Graus' campaign. The first is the insufficient allocation of resources for Castilian people population. The second, acts of violence against Castilians. And third, unlawful detainment of Castilians. The plan of eradicate Castilians began December 15 in 2015. Mr. Graus' government was based on the nationalist ideas, and no Castilians were named on the governmental position. It meant that the majority of Hanatun were in much better condition than minorities of the state, and it states the fact that the members of other groups were spared. Castilians were killed solely on the count of having been born Castilian. They were detained without any investigation, and the only reason why they were detained was that they were Castilians. And it's stated by the testimony of Mr. Rix, who was released after the fact that it was found he was not Castilian. The only it's obvious that Castilian targeted especially because of their ethnicity. And in any case, the Castilian children and pregnant women naturally not have been among the fighters, and attacks against them were unlawful. Intent to destroy Castorians is precisely expressed by the Mr. Grau's words. He named Castorians line grades and cancer, and it means that the term eradicate means that his will was to destroy the Castorians at all. By the cases, and it was defined under paragraph 110 in Akayesu case and paragraph 44 of Rigo case, where it states that the mention of ethnic group in public speeches like cockroach and go work and call wipeout confirm the judicial intent. In this case, the term cancer and line grades became synonymous to the term Castorians. To describe Castorians as cancer meant for others that it was necessary to remove Castorians from them. Your Honor, there are all elements or fourth element which was mentioned in the beginning, and hence it was committed that this crime is under the jurisdiction of court under Article 19 of the Rome Statute. Your Honors, with your permission, I will move on the third issue and state that Mr. Graus was the president of the Hanatun.
So you have a minute. You have
Yes.
a minute.
Thank you, Your Honor. I will submit all the elements, and the prosecution stated that there are reasonable grounds that Mr. Graus was the president and commanding chief, and he was. There was the direct fact that all the divisions should submit personally to him about all the situation, and he has direct command to his subordinates. However, there is the fact that superior need not share to special intent to destroy the element required on the base of crime, and also commanders and superiors are made responsible for crimes committed by their subordinates as a result of their failure of control by them. Your Honors, by the last sentence, I will submit all our submissions, and according to the facts, it's clear that the case against Mr. Graus concerning genocide falls within the jurisdiction of the court pursuant to Article 17 and 19, and Mr. Graus is criminally responsible for the crime of genocide under Article 28 of the Rome Statute. Thank you. If there is not, thank you.
Thank you, counsel. Thank you for your submissions. We now move to the defense. You have the floor.
Thank you, Excellency. Your Excellencies, may it please the court, I'm Ishan Arachi, and along with my co-counsel, Teshani Veligamage, I'll be representing Mr. Graus in today's proceedings. There are three issues that need to be addressed by this court in the present case. I will be dealing with the first issue, and my co-counsel will deal with the rest. The first issue is whether the case against Mr. Graus is admissible pursuant to Article 17 of the Rome Statute. Your Excellency, since this is an admissibility challenge to the proceedings before this court, it is of procedural nature. Therefore, the persons involved in this issue and their intentions have a little bearing on the decision whether the case against Mr. Graus is admissible. What really matters with regards to an admissibility challenge is the nature of the investigation at issue, and particularly whether it satisfies the criterions laid down in the Article 17 of the Rome Statute. Therefore, the submission of the defense will cover the same. Your Excellencies, in the Lubanga decision, in paragraph 29, this court treated the admissibility test as involving two main parts. Firstly, the criteria set out in Article 17A to C, which is commonly known as this complementarity test. And secondly, the gravity threshold under Article 17(1)(d). The submission of the defense is based on four main arguments. First, the case under consideration is being investigated or prosecuted. Second, the Republic of Hanatun is willing to carry out the investigation. Third, the Republic of Hanatun is able to carry out the investigation. And fourthly, the case is not of sufficient gravity. Your Excellency, with regards to my first argument, in the prosecutor versus Thomas Lubanga, in paragraph 20, pre-trial Chambers stated that, and I quote, "It is a condition sine qua non for a case arising from the investigation of a situation to be inadmissible, that national proceedings encompass both the person and the conduct, which is the subject of the case before the court," unquote. This is commonly known as the same person, same conduct test, and it has been followed in many cases as the standard to be applied in determining whether there are ongoing investigations or prosecutions. In the Kenya cases, particularly in paragraph 54 of the Ruto admissibility decision, this court held that an investigation does not satisfy the same person element in the said test if the ongoing investigation is not directed against a subject in the case before the International Criminal Court. In Prosecutor versus Saif al-Azim Gaddafi, this court held that the sameness of the case depends on the degree of the overlap between the incidents investigated by the court and those carried out at the national level. And an examination of whether the state is investigating exactly the same conduct as those before the court is not needed. Therefore, Your Excellency, contrary to what the prosecution submitted, in the present case, the prosecutor is investigating the situation in the Republic of Hanatun as of March 2019, whereas the military tribunal is investigating the crimes committed in the conflict regions as of 3rd November 2015. Therefore, Your Excellencies, the domestic prosecution covers not only a substantial part, but the entirety of the investigation carried out by the prosecutor. Your Excellencies, in the case at hand, a warrant of arrest was issued against Mr. Graves on 15th September 2021. On 10th December, a military court was established to investigate the crimes committed in the conflict regions as of 3rd November 2015. The recommendations by the high-ranking military officers to release Mr. Graves also shows that he is in fact under investigation. Therefore, Your Excellencies, the Kenya cases where the government investigations did not specify the persons under investigation can be distinguished from the present case. Accordingly, the investigation into the crimes committed in the conflict regions satisfies the same person, same conduct test. Your Excellencies, my second argument is that the Republic of Hanatun is willing to carry out the investigation. According to Article 17(2) of the Rome Statute, in order to determine the unwillingness in a particular case, the court shall consider 3 main grounds. The facts of the present case, however, do not establish any of them. First ground, Your Excellency, is that the proceedings are not being undertaken for the purpose of shielding the person concerned from the criminal responsibility. The concept of shielding from criminal responsibility is considered proportionate to an ineffective investigation. Although this court has not spelled out the meaning of an effective investigation in clear terms, the decisions of the human rights bodies are relevant to the determination of whether a particular investigation is effective. This is mainly because Article 21(3) of the statute requires that the application and interpretation of the law of the statute must be consistent with internationally recognized human rights. The decisions of many human rights bodies regarding the effectiveness of the investigation focus on assessing whether the state intends to shield a person from criminal proceedings from an objective standpoint. Your Excellencies, contrary to what the prosecution submitted in this case regarding the concrete steps in proceedings, in Nakoya versus Bulgaria, in paragraph 113, the European Court of Human Rights held that authorities must take all reasonable steps available to secure the evidence concerning the incident in order to carry out an effective investigation. The intensities of such steps, which the state should undertake, was explained in paragraph 181 of Rodriguez versus Honduras, that the Inter-American Court of Human Rights held that the effectiveness of the investigation must be determined according to the available means for the state. Your Excellencies, although the prosecution submitted that this case, this investigation is a result of the pressure from national and international human rights bodies, in this case, there was no resistance whatsoever from General Hitch or his government to the requests made by national and international human rights organizations. Mr. Graves remaining present.
Council, if I may interrupt, just would like us to explore further on your point on effective investigations. Could you address this court or table evidence that demonstrates that the investigations being undertaken against Mr. Graves are effective based on the standards you've articulated, but also the standards that this court has established?
Yes, Your Excellency. Your Excellency, in this case, Mr. Graves remained in prison while the investigation was carried on. So there was no shielding the person in that regard. And also it was carried out by a military court. Your Excellencies, this reflects the attempt by the state to use all the means at disposal, which is a standard laid down by the decisions of the human rights bodies, because all 3 branches of Hanatun have been under military rule. Therefore, Your Excellencies, the investigation by a military court was the only means available at the disposal of a state governed by a military regime. In fact, Your Excellency, as the European Court of Human Rights noted in Nakoya versus Bulgaria, where there are deficiencies in a process, they are deemed to affect the decision of the effectiveness of the process only if they are not accompanied with a proper explanation. However, Your Excellency, in this case, the political circumstances of the Republic, which was governed by a military regime, clearly provide a proper explanation as to why the investigation is carried out by a military court. Therefore, Your Excellency, in this case, the effectiveness of the investigation satisfies according to the criterions laid down by the International Tribunal, especially the criterion that the state must use all the means at disposal to carry out the investigation. Your Excellency, my second argument is that the proceedings are being conducted independently or impartially. A number of human rights decisions, Your Excellency, regarding the independence of the military tribunals point towards the fact that the investigations by a military tribunal are not per se considered to be not independent. However, the independence of investigation can be affected if the members of the tribunal are subordinate to the parties to the investigation. Your Excellency, in this case, although the investigation is carried out by military court, its members are not subordinate to Mr. Graus since his regime is already toppled. Therefore, he is not in a position to influence the military court. Also, Your Excellency, in the present case, the only evidence relating to the impartiality of the investigation is the recommendations made by the high-ranking military officers regarding Mr. Graus's relief. Your Excellencies, although the prosecution submitted that there is no evidence to establish that the independence of the military tribunal, that this tribunal has not released Mr. Graus despite the requests by the high-ranking military officers. Furthermore, Your Excellency, the clarifications to the moot problem also emphasize that they have no connection to the military court. Furthermore, Your Excellency, this court held in al sensu decision that the statements made by public officials, which might violate the suspect's presumption of innocence, are not sufficient to taint the domestic process. What matters is whether the statements were made by the members of the judicial authorities dealing with the case. Therefore, Your Excellency, there is no basis to submit that the statements or the facts of the case reflect partiality of the investigation. Your Excellency, regarding the ability of the state to carry out the investigation, it is submitted that a substantial collapse is needed, substantial or a total collapse of the judicial system is needed to establish this element. However, this can be established only if it entails a degree of intensity that is sufficient to paralyze the system in fulfilling its functions regarding the investigation, prosecution, trial, and execution of the accused. In this case, Your Excellency, the very fact that the allegations against Mr. Graus are investigated by court means that even if there may have been breakdown in the system due to the takeover of the government, there is no evidence to suggest that it has been to a degree of intensity sufficient to paralyze the system. Furthermore, Your Excellency, regarding the gravity threshold, the defense wishes to dispute the quantitative element that the prosecution submitted. Although the prosecution submitted that the gravity threshold has not been met, it has not submitted any analogy to this court. However, in the situation in the Republic of Kenya, this court held that the gravity threshold was met only because in that case, more than 1,133 murders were there. More than 900 acts of documented rapes and sexual violence was reported. Approximately 300,000 and 350,000 displaced persons were there. However, Your Excellency, in this case, the total number of victims only amounts to less than 500 people, including the 200 Castrian men who were killed and also 180 women who were subject to numerous difficulties. Therefore, Your Excellency, the defense submits that the quantitative factor of the gravity threshold has not been met in this case, contrary to the submission of the prosecution. Your Excellency, if I can be of no further assistance, this concludes my submission and I yield the floor to my co-counsel. Thank you.
Thank you. Counsel, you have the floor.
Your Excellency, may it please the court. My name is Teshani Baligamage and I will be appearing as a defense counsel on behalf of Mr. Gravis in this case. During my submission, firstly, I will be submitting that this case against Mr. Gravis does not fall within the jurisdiction of the court. And secondly, that Mr. Gravis is not criminally responsible for the alleged crime. Drawing your attention towards the preconditions of jurisdiction, Your Excellency, the defense submits that this case does not fall within the jurisdiction of the court. As a subject matter jurisdiction, ratione materiae, has not been fulfilled as the material elements of genocide have not been met in this case. Your Excellency, it suffices for the defense to prove that even only one of the preconditions of jurisdiction have not been met for there to be a lack of jurisdiction. Thus, the defense will make a threefold submission with regards to this. Firstly, the defense contends that the contextual element defined in Article 6A4 and 6A5 is not satisfied. Secondly, persons belonging to a particular national, ethnic, racial, or a religious group have not been targeted, which the prosecution brought out as a protected group. And thirdly, the specific intent or dolus specialis required in establishing genocide have not been met in this case, and therefore this case against Mr. Graves does not fall within the jurisdiction of the court. Your Excellency, Article 5A of the Rome Statute declares genocide to be one of the crimes which the ICC has jurisdiction over. It is a crime of crimes, and the PTC has held the reasonable basis standard to proceed must not be interpreted widely for if PTC is to have a purpose. It is to avoid politically motivated, frivolous cases going ahead only to result in needless trials and acquittals. Thus, Your Excellency, it is required that the requisite elements of genocide are met in order to establish jurisdiction. Your Excellency, we firstly submit that the contextual element in Article 6A4 and 6A5 is not satisfied. To prove genocide, the contextual element defined in Article 6A4 and C5 must be satisfied as per the ICC elements of crime, and it is that the conduct must have taken place in the context of a manifest pattern of similar conduct directed against a group or misconduct that could itself effect such destruction. Your Excellency, according to paragraphs 7, 8, and 9 of the Moot problem, CNF terrorized the public and disrupted order through their demonstrations by taking up arms, which resulted in the death of many. As the President, Mr. Graves had a duty to protect the national security, and thus he was compelled to act against this group of terrorists to protect the national security and the public order of Hanaton. And Your Excellency, taking steps against terrorism is a legitimate objective defined in international law, as outlined by United Nations Security Council Resolution 1624 of 2005. Further, Your Honor, even throughout this campaign, communications with the head of NDS show that he always inquired from Ms. Jolie whether the civilians remained unharmed. And Your Excellency, this element specifically requires the conduct to be in such a pattern, a coordinated plan of different actions aiming to destroy a group. According to the case of Barushimana, paragraph 40 and 41, the evidentiary threshold against which the PTC makes the determination is relatively high and should be sufficient to justify the case proceeding into trial. There must be concrete and tangible evidence to ensure no unfounded charges are made. Your Excellency, the defense contends that in this case, there is no manifest pattern of similar conduct directed against Castilians to bring about their destruction. Firstly, all the incidents in Luzan-Luzari were reported only by IHRD and no other corroborative source. And not only these are uncorroborated, they are disputed evidence, as Mr. Bryan has explicitly rejected these claims as demonstrated through paragraph 12 of the Moot problem. Secondly, Your Excellency, in the case of Luz and Cecil, the social media images are the only source from that period showing death due to famine. Therefore, there is no manifest pattern of similar conduct directed against Castilians to bring about their destruction. Secondly, Your Excellency, we submit that the persons belonging to a particular national, ethnic, racial, or a religious group have not been destroyed in this case. For in effect, the protected group has not been targeted as the persecution, contrary to what the prosecution submitted. Your Excellency, according to the elements of crime, the conduct must be against a particular national, ethnic, racial, or a religious group. This element fails since, firstly, Mr. Graves's campaign was anti-terrorist and not anti-Castilian, as demonstrated through paragraph 11 of the case facts. And his actions were to protect the peace and order of the country from the CNF terrorists. Further, Your Excellency, his press statements emphasize only on eradicating the threat posed by CNF terrorists and not Castilians. As the information of the Moot problem depicts to us, in Luzan-Luzari, the purpose was to capture terrorist suspects and not to target any particular ethnic group. Your Excellency, Castilla is populated not only with Castilians, but other ethnic minorities as well, as stated by paragraph 4 of the case facts, and further clarified by clarification 1 of the Moot problem. CNF has not consisted only of Castilians, but was inclusive of other minorities as well. Furthermore, Your Excellency, Mr. X's release indicates that there were proper inspections to only arrest CNF terrorists and not civilians. And Your Excellency, the blockade was created to prevent locals. Yes, Your Excellency.
Paragraph 12 of the case facts also tells us that of the 200 people killed during the searches, only 2 were CNF members. So how do you square that with the proposition you made that it was only CNF terrorists who were targeted?
Your Excellency, we understand your concern. If I may draw your attention to paragraph 12 of the Moot problem, Your Excellency, it states that the searches were carried out to find the suspects of find the terrorist suspects, Your Excellency. So therefore, it does not portray the genocidal intent. And therefore, Your Excellency, it is the submission of the defense that the men that is brought out through this piece of information pertain to those that were CNF terrorists, which was a target of the July searches. And further, Your Excellency.
Counsel, if I may also interrupt, drawing your attention to the facts before this court, paragraph 11, which Mr. Graves directs that the should take measures to destroy CNF terrorists and Castilian supporters. Could you how the Castilian supporters were to be identified?
Yes, Your Excellency, we understand your concern. In response to that question, Your Excellency, the defense contends that a closer reading of paragraph 11, with regards to counterterrorism campaign, outlines that the instructions has been given to destroy CNF terrorists and the Castilian supporters of those terrorists who were a threat to the national security and the public order of Hanaton. Nowhere in the Moot problem, Your Excellency, it has been, Mr. Graves has given an instruction to the subordinates to capture civilians, and further Exhibit 1 specifically categorically demonstrates that Mr. Graves has made sure that the civilians are unharmed. Therefore, Your Excellency, defense contends that noting that the genocidal intent has not been established, and further, Your Excellency, since a specific protected group has not been targeted, the material elements of genocide have not been met, and therefore, Your Excellency, the genocide has not been established in this case. Your Excellency, if I may move ahead with my submission. Your Excellency, as I was contending, Your Excellency, it is our submission that the acts of Mr. Graves were not targeting a particular national, religious, or ethnic group. Third, Your Excellency, with regard to the dolus speciale, the specific intent, it is our submission that the specific intent with regards to genocide have not been fulfilled in this case. According to the elements of crime, Your Excellency, the perpetrator must have intended to destroy in whole or in part that ethnic group. Only if the crime has been committed with intent and knowledge would the person be liable for it. In the case of Radoslav Brajanin, paragraph 695, the chamber held that the specific intent is the element which characterizes the crime of genocide. Therefore, it must be established not only that the suspect has committed the acts, but also that he has had specific intent to target a particular ethnic group to bring about the destruction from those acts. Since genocide is a crime of intent, what matters is the purpose of the perpetrator and not the result. Where direct evidence of genocidal intent is absent, the inference intent may still be inferred from the factual circumstances of the crime, but this inference may be the only reasonable one, as was stated in the paragraph 930 of Brajanin case. Your Excellency, the arrests in Luzern, Luzari, and the blockade and shutting down the local businesses were to protect the Castilian territory from terrorist attacks. And since it is well known for the natural resources and for Castilla is known for its economic prosperity, it negates the possibility that Mr. Graves deliberately inflicted these conditions in order to bring their destruction. Furthermore, Your Excellency, as stated in paragraph 548 in the Akayesu trial judgment, although the victims could have been deprived of food, water, if these deprivations were not deliberately created with an intention to bring about their destruction, this does not amount to genocidal intent. Therefore, Your Excellency, in noting that in this case, the intention was to safeguard the territory from CNF terrorist attacks, the prosecution's claim fails. Thirdly, Your Excellency, responding to the prosecution submission that Mr. Graves's statements provide the genocidal intent with regards to Castilians as lying rats and Castilians are cancer. Your Excellency, the defense would like to contend that as stated by paragraph 10 of the Moot problem, Mr. Graves has categorically denied these allegations and stated that the media had distorted these evidence. And second, Your Excellency, as per Brejanin trial judgment, paragraph 987, the utterances of this with the demonstrators' discriminatory intent does not suffice to establish genocidal intent. Therefore, explicit genocidal intent to destruct a particular ethnic group is required to suffice to sufficiently meet the requirement of specific intent. Therefore, Your Excellency, noting that the specific intent has not been met, it is a submission that this court does not have jurisdiction for the case at hand. In the event that Your Excellency's court is to hold that the preconditions of jurisdictions have been fulfilled and it is admissible before this court, even in that case, the defense still contends that Mr. Graves is not criminally responsible for genocide. Your Excellency, the defense admits that Mr. Graves is not responsible under Article 28A for command responsibility for the alleged crime. The responsibility under Article 28A depends on the fulfillment of 6 conditions, legal conditions, pursuant to Prosecutor versus Bemba case as according to paragraph 170. And the defense contends that the prosecution has failed in establishing command responsibility, as in the present case, conditions of effective control, knowledge, taking necessary and reasonable measures, and the condition of causal link have not been met, and therefore Mr. Graves is not criminally responsible. As for the first element, Your Excellency, with regard to effective control, according to Prosecutor versus Bemba, paragraph 190, it stated that some factors—
So you have a minute left, so try and wrap up.
Yes, Your Excellency. Noting that, Your Excellency, we submit that the existence, according to the case, Bemba case, it was stated that disregard or non-compliance with orders or a weak malfunction in chain of command would absolve the effective control element. And therefore, Your Excellency, noting that what has been portrayed by IHRD reports and the social media images are contradicting to what Mr. Graves's intent portrayed through anti-terrorism campaign. It is our contention that there has been a non-compliance, and further, Your Excellency, as Exhibit 1 demonstrates, Mr. Graves himself has had to reach out to his subordinates to request updates. Therefore, we submit that there has been an effective control. Moving on to the element of knowledge, Your Excellency, as stated in paragraph 430, actual knowledge cannot be presumed, and it is our submission that actual knowledge neither should have known standard has been met. Therefore, Your Excellency, since the time has exceeded, the defense contends that this case is inadmissible, does not have the jurisdiction, and does not have Mr. Graves is not criminally responsible for the case at hand. If the counselor is of no further assistance to the court, this concludes my submission. Thank you.
Thank you, Counsel. Thank you. Now we move to the rebuttals. We start with the prosecution. You have 5 minutes.
Thank you, Your Honor. Thank you. For the rebuttal, I would like Your Honor, so with your permission, as a preliminary comment, I would like to clarify the answer provided by co-counsel and reaffirm that the Security Council are not sufficiently grave. The given evidence satisfies the required criteria. Regarding our rebuttal, the OTP submits the next point. The first is about the effective investigation. It was not the OTP's submission, contrary to what the defense tries to argue, that the national investigation should cover the exact same case. However, the defense did not meet the evidentiary standards to show that substantially same conduct is covered by the effective investigation. The next issue, the second issue of the prosecution is about the gravity and quantitative element of the crime, and as the prosecution states that there is no upper lower limit for the crimes of genocide for the protected group. The third issue of the prosecution is about the security means which don't justify the acts of violence and crimes of genocide. And as your honors has mentioned, only the 2 terrorists were died during the conflict. And also the last and final submission of the notice is the specific intent of Mr. Graus. The specific intent of Mr. Graus was expressed by his words and acts, and also commander and superiors made a responsibility for crimes committed by their subordinates as a result of the failure to exercise control properly case. As it was declared in the case of Brannon, paragraph 721. There is all submissions of prosecution. If there is not any questions, thank you.
Thank you very much, counsel. Now we move to the defense for the rebuttal.
Thank you, Excellency. I will deal with the first 2 points of the rebuttal, and my co-counsel will deal with the rest. With regards to the exact the same person, same conduct test, Your Excellency, I reiterate what I submitted in my submission as well. In prosecutor versus Gaddafi case, as well as Al-Sensu case, this court held that the sameness of the cases depends on the degree of overlap between the incident investigated by this court and those carried out at the national level. And an examination of whether the state is investigating exactly the same incidents as before this court is not needed. Furthermore, Your Excellency, in prosecutor versus William Ruto case, this court held that often no individual suspects will have been identified at this stage, nor will the exact conduct, nor its legal classifications be clear. Therefore, Your Excellency, again, contrary to what the prosecution submitted in the present case, the prosecutor is investigating the situation in the Republic of Hanatun as of March 2019. The military tribunal is investigating the crimes committed in the conflict regions as of November 2015. Therefore, the domestic investigation covers the entirety of the investigation carried out by the prosecution, not only a substantial part. With regards to the gravity threshold, Your Excellency, although the prosecution submits that more than 200 Castilian men have been murdered and other allegations, they don't lay down a criteria to be satisfied by this court to come to a conclusion on the gravity threshold. However, Your Excellency, have drawn an analogy with the case in the situation of Republic of Kenya, where the number of victims were higher than more than 1,000. In one case, there were more than 350,000 displaced persons, and there were more than 100,000 murders and more than 900 acts of documented rapes. Therefore, Your Excellency, the number of victims in this case, which is less than 500, does not even come near to this quantitative criteria which has been considered by the situation of Republic of Kenya. Therefore, Your Excellency, the defense submits that the quantitative criterion in the gravity threshold has not been met in this case. I yield the floor to my co-counsel. Thank you.
Your Excellency, may it please the court. The defense would like to respond to the 3 points of rebuttal that was brought forward by the prosecution with regards to jurisdiction and command responsibility. Firstly, Your Excellency, with regards to the specific intent, as the prosecution claimed that the prosecution brought forward the argument that as given by paragraph 12 of the Moot problem, the killings of 200 men and 2 CNF terrorists portray the specific intent, but as per the defense contends that that the specific intent is not portrayed by this. For this, we have a twofold submission, Your Excellency. If I may draw your attention to paragraph 12 of the Moot problem, it states that NDS and SPG have started searching houses for the suspects of the military ambush, and further, they have been finding suspects. They have been finding people who engage who had affiliations with the CNF terrorists, and therefore, Your Excellency, this noting that the intent does not portray a genocidal intent. However, the intent is to capture the CNF terrorists who disrupted the national security of Hanatun. This element fails. And second, Your Excellency, with regard to Mr. X's statement, Your Excellency, if I may draw your attention to paragraph 13, a closer look at the paragraph portrays that Mr. X has been a local resident, which means that he has been a Castilian. And Your Excellency, further, the very fact that CNF forced him to state that he was a member, he had affiliations with CNF, what it portrays is that the intent was to capture CNF terrorists, but not to commit genocide with regard to this group. Therefore, Your Excellency, we respond to we claim the defense contends that the specific intent has not been established. And further, Your Excellency, with regard to the command liability taking necessary and reasonable measures, Your Excellency, we submit that with regard to this element, it is needed that measures to prevent, repress the crimes should have been taken. However, Your Excellency, the duty to prevent arises if the superior knew or should have known that the forces were under his effective control, were committing or were about to commit crimes. However, Your Excellency, if we look at, if we demonstrate the situation in the case at hand, Your Excellency, Mr. Graves has not been presented with knowledge, therefore actual knowledge element has failed. And Your Excellency, if the command has genuine reasons to doubt the accuracy of a given source of information, it may absolve the commander from superior liability under the standard of should have known, as was stated in paragraph 43 of the separate concurring opinion of the Bemba case. Therefore, Your Excellency, if I may draw your attention towards the IHRD claims, which were refuted by Mr. Bryan, this gave a valid reason for Mr. Bryan, Mr. Graves to doubt the accuracy of that. And that is why, in fact, Mr. Graves ensured by the text message of Ms. Jolie that civilians are unharmed. Therefore, Your Excellency, noting that Mr. Graves has ensured that the civilians are unharmed, it is our submission that he has taken effective measures and necessary and reasonable measures within his power to prevent and repress the commission of such crimes. And further, Your Excellency, since the prosecution has not been able to establish actual knowledge or neither should have known standard explicitly, without the knowledge of the crimes, it is impossible to take necessary and reasonable measures. Therefore, Your Excellency, we contend that the prosecution has not established jurisdiction and command liability.
Thank you, Counsel. Your time is up. Thank you. Unless members of the bench have a question for the parties, we've come to the end of this hearing. The bench is going to retire to deliberate, and we will return with our decision. Thank you very much. Okay. Bench clerk, would you like to read the case?
If I would like to read the case.
Okay, if we don't need to do that, then we can proceed. So thank you very much to the teams again for your participation in this round. Very rich arguments, the preparation involved, and we could all see that you're all passionate international criminal lawyers. So thank you very much for that. Before we announce the results, I'll invite Judge Nicolai to share the bench's collective insights and also advice and comments to the teams. Thank you, Judge Nicolai.
Thank you, Madam President. First of all, thank you very much to both teams for the presentations you gave us. Second of all, of course, congratulations for making it this far. It's quite demanding to get to this point, but we felt like it is well deserved that it was the two of you sitting in the last 16 round. So very well done on that. In particular, we liked that the way you structured your presentations, the way you gave us a way to go with you and then presented your points clearly and concisely. Also, you referred us to jurisprudence and why we should look at human rights jurisprudence as per Article 21.3 from the statute. So that was quite well done. Also, the level on which you argued your cases were quite good, we felt. In terms of room for improvement, it would especially be regarding rebuttal and surrebuttal. We know you have prepared your submissions for 25 minutes, you know what's coming, and you've done that exceedingly well. You could improve, both teams could improve in terms of rebuttal and surrebuttal, because this is where you have to go off script. You don't address things you have prepared, but you're addressing things you just heard from the opposing team, and that is that team in particular. And while we felt it was good too, both teams have room for improvement on that, because that's what we want to see in a moot court competition. That is what the competition is about. So much for terms for room of improvement, but in general, again, very well done regarding the facts, regarding the law, and it was quite a pleasure to listen to you both. Thank you very much.
Thank you very much, Judge Nicolai, and I re-echo his thoughts that congratulations to all of you for making it to the round of 16, and it's been a real pleasure listening to you and your arguments. Now, we have the honor to announce, we'll start by announcing the best speakers, and then we'll announce the winning team. In terms of the second best speaker, we found Ishan from the defense was the second best speaker. Congratulations, Ishan. And the overall best speaker is Tamar from the prosecution, Team 28. So congratulations, Tamar. Whereas both teams were quite good, and I said your arguments were very persuasive and grounded in law, the bench concludes that the prosecution was the best performing team in this round. So congratulations to the prosecution team. Thank you very much. And with that, court is adjourned.
Thank you very much. Thank you very much, Your Honor. Thank you for the best advices, and thank you for the second team for the great rebuttals and rebuttal. Thank you so much.
Thank you very much, Excellencies, and congratulations.
Thank you.